Welcome to Term Talk, the video podcast from the Federal Judicial Center that covers the Supreme Court decisions from each term that are likely to have the most impact on lower courts. I'm Beth Wiggins, the Director of the Research Division at the Federal Judicial Center. We're going to discuss United States Trustee versus John Q. Hammons and Harrington versus Purdue Pharma. Both cases arose in the bankruptcy context. One involves the appropriate remedial remedy for a constitutional violation, and the other involves the inclusion of releases from liability of third parties in bankruptcy reorganization plans. Joining me today are Tara Grove, Vinson and Elkins Chair in Law at the University of Texas School of Law, and Melissa Jacoby, Graham Kenan Professor of Law at the University of North Carolina at Chapel Hill. Thank you both for being here today. Let's start with United States Trustee versus John Q. Hammons. The bankruptcy system is administered by two programs. In 6 judicial districts, it's administered by the Bankruptcy Administrator Program under the supervision of the Administrative Office of the U.S. Courts, and in all other districts by the United States Trustee Program that's housed in the Department of Justice. Melissa, can you take us through the history of the Hammons case? What's at issue there, and what did the court decide?
So let's start with 3 issues to set the stage. The first, Beth, you've mentioned that we have separate administrative oversight in North Carolina and Alabama, the 3 federal districts there, and everywhere else by the Department of Justice. And that's really important to see for this case, as you mentioned. The second point is that the bankruptcy system relies very heavily on private funding to operate, particularly user fees. So those fees are what creates the disparity that was challenged here constitutionally, because there was a period of time where companies in most of the country under the U.S. Trustee Program were paying much higher fees than the companies that filed Chapter 11 cases in the 6 districts in Alabama and North Carolina. And then the third really important piece is that the bankruptcy clause of the Constitution calls for uniform terms of bankruptcy. And so that's been challenged sometimes, but rarely successful. So this case is very significant in that way. This all flows out first from a prior Supreme Court decision from 2022, Siegel versus Fitzgerald, where a company challenged having to pay higher fees in a U.S. trustee district relative to those few districts in Alabama and North Carolina. And unanimously, the Supreme Court held that the disparity of fees violated the uniformity element of the bankruptcy clause, and that the bankruptcy clause offers Congress some flexibility, but it couldn't be arbitrary when we were talking about similarly situated debtors in different geographical locations. So that raises the question, what is the remedy? So the Supreme Court didn't determine that remedy in that case, which is what leads us back to Hammons. But let me make clear that even before Siegel versus Fitzgerald was decided, Congress already closed the gap and stopped the non-uniformity. So this was a time-bounded non-uniformity. So when it goes back up to the Supreme Court in the Hammond case, from a company in the 10th Circuit who wants their money back, and the 10th Circuit said they should get a refund to match those lower districts. We already know the problem is fixed prospectively. The question is retrospectively. And yet here we have 6 justices in the Hammons case saying, you don't get a refund. All those companies don't get a refund. Congress fixed the problem. No retroactive remedy is necessary.
So, Tara, how did the court come to the decision?
So the court looked at the overall statutory scheme and said the intent of Congress was to have a self-funding bankruptcy system, particularly with respect to the office of the U.S. trustee. And so it didn't make sense to really create an enormous price tag, especially for something that Congress had already fixed going forward. And so the court, in an opinion led by Justice Jackson, said, this is fine, it's not a big deal, this is really a de minimis problem. And I do want to say it was an interesting lineup. So Justice Jackson wrote the opinion for the court, joined by Chief Justice Roberts and Justices Alito, Sotomayor, Kagan, and Kavanaugh. And it was Justices Gorsuch, joined by Justices Thomas and Barrett, that dissented. So that's not exactly the lineup people expect. And I think that's an important feature of this case and many other cases in the bankruptcy context and others, particularly when it comes to statutory interpretation.
How did it see the issues differently?
So the dissenting opinion said when there is a violation of a right, there should be a remedy, especially when there's a violation of a constitutional right, as there was in this case. And they said Congress has provided funds that could be used to pay this. And so there's really no reason not to provide a remedy. What's interesting about that is that there are lots of areas of constitutional law where there is no remedy, even when there is a violation of a constitutional right. So when one looks at areas of constitutional torts, many public officials are sued, found to be in violation of the Constitution, and don't have to pay anything because of doctrines like qualified immunity and absolute immunity. As many people may know, the Supreme Court just granted presidents not only absolute immunity in the civil context that already existed, but also in the criminal context. So there are many times when there can be violations of rights, including constitutional rights, where there is no remedy. And in fact, several of the justices in dissent have joined opinions where there has been no remedy. So it's interesting that in this context, the dissenters are so concerned about the lack of a constitutional remedy.
So, Tara, what are the takeaways for the lower courts of this decision?
So it's going to be interesting to see what happens. As Professor Jacoby already noted, there have been efforts to challenge bankruptcy requirements for lack of uniformity under the bankruptcy clause, and those efforts have largely been unsuccessful. In fact, there's a tremendous amount of disuniformity in the bankruptcy system because so much of the bankruptcy system relies on state law and different state requirements. And the Supreme Court has generally been pretty solicitous of those different requirements. And so it's going to be interesting to see if these two decisions combined lead a lot of litigants to mount challenges to bankruptcy provisions for lack of uniformity, particularly since in this case, yes, there was a constitutional violation found, but there was no actual remedy, which may be something that disincentivizes litigants from going forward.
Mm-hmm. Melissa, would you like to add to that?
Well, first, I just want to echo and underscore what Professor Grove just said. There is so much non-uniformity in bankruptcy. Some of it is because of state law, absolutely. Some of it is just different practices in different parts of the country, and there's also evidence that some debtors are treated differently than other debtors in the same district. So I do wonder about future challenges. And I would note that many of those are not just about money. So they are about fixing the problem. And here we can't forget, Congress did go in and fix the problem, at least prospectively. I recognize there was a retrospective period, but in terms of some of the most fundamental non-uniformities in the system, statutorily fixing them would be quite a big step, even if there was no financial compensation. I would only then add pragmatism in the analysis. We know that pragmatism plays a role in lots of types of cases, but we see it a lot in bankruptcy cases. It would have been hard to send the money back. And as Professor Grove said, that's not always the norm to remedy constitutional wrongs. So, but I did want to highlight the pragmatism element when looking at bankruptcy cases. Not that they should be different, but sometimes we see that they could be.
Thank you. Well, why don't we move on to Purdue Pharma? This case involves a tool that's been used in all sorts of bankruptcy cases, but it's particularly prominent in mass torts and other similar cases. That is the release from liability of non-parties for claims against them. Tara, can you take us through the facts of this case? What was at issue and how did the majority resolve it?
So this case arises from a really tragic set of facts and something that's been happening throughout the country. The costs of opioids and what they do to populations and what they've done to many, many people across the country. So Purdue Pharma, the debtor at issue here, was the maker of OxyContin, I think the most famous of all the opioids. And this product was marketed as being something that would be a pain reliever and was probably not going to be addictive. And yet it turned out to be extremely addictive and extremely problematic for many, many people. So the Sackler family that owned Purdue Pharma eventually saw the writing on the wall and thought, okay, our company is probably going to be sued. What are we going to do to protect ourselves? And so the Sacklers actually took about $11 billion out of Purdue Pharma and sent them off to various accounts to protect themselves as a family, with the expectation that their company was probably going to be sued, and sued by many, many people, and indeed it was. Purdue Pharma eventually filed for bankruptcy, and that is a way of resolving lots and lots of claims against a company, but also in this case raised the question, well, what do you do with that $11 billion that the proprietors of Purdue Pharma took out? So the Sacklers realized that they themselves could be sued for their involvement in selling OxyContin. And so in the process of negotiating a bankruptcy settlement, the Sacklers asked to be released from any kind of liability by anyone that had taken OxyContin. And the bankruptcy court eventually agreed to do this once the Sacklers agreed to put about $4 billion back into the amount that Purdue Pharma could pay out to the creditors here being the victims of OxyContin. So the case continued forward. A number of people complained about this arrangement, that the Sacklers were getting off scot-free. And eventually on appeal, they added some more money. So I think it was about $6 or $7 billion that they had put back in total into the amount, which was going largely to states and localities that were helping to pay for the health insurance issues that had been caused by OxyContin, but some amount was going to individuals. Not as much as one might think, anywhere between $3,800 and I think about $48,000 might go to the individuals. And I think for many onlookers, they would expect a whole lot more to go to the private individuals who are actually affected by the drug. But this is one of the things that happens in bankruptcy, right? People do not actually get the full amount of their damages. They get a pro rata share, and sometimes that pro rata can be pretty small. And I think that complicates the situation quite a bit. Now, at the end of the day, a number of the creditors involved, that is the states and localities that had paid for problems caused by OxyContin, as well as a number of the individuals who had been harmed by OxyContin, agreed that this was not an ideal solution, but it was the best that they could get. And so they agreed, hey, let's go ahead and have this reorganization plan. Let's just end this fight now. But there were a few people who complained, including the United States government. The United States government said this is not actually authorized by the text of the bankruptcy code. And so the question here was, does the bankruptcy code actually allow a bankruptcy court to basically release any sort of claim against someone who is not actually the debtor? Now, I think this is a little hard for people who are not steeped in bankruptcy to understand, because the Sackler family was so closely associated with Purdue Pharma, it's hard to see them as separate entities, but they were. Purdue Pharma, the company, was the only debtor in bankruptcy. The Sacklers were just these people who had taken money from the debtor in bankruptcy. And the question was, can a bankruptcy court say that those folks who didn't ever file for bankruptcy nevertheless can get what amounts to complete relief from liability for any claims that involve this debtor? The bankruptcy court said, yes, they can. The Supreme Court said, no, they can't. That is not allowed by the statutory text. And what this came down to was a statutory text that involved what kinds of things can be in the plan. Most of that stuff says that the bankruptcy court can basically absolve the debtor of any kind of liability, and those who have claims against the debtor. It also says that the plan may, quote, include any other appropriate provision not inconsistent with the applicable provisions of this title, end quote. And the lower courts had read that to mean, hey, that's pretty broad power for the bankruptcy court. This kind of makes sense, and this plan will actually let the bankruptcy go through. The Supreme Court said no, can do. The bankruptcy code does not authorize this.
So Melissa, would you like to say more about how the court got to its decision?
I'll just add a couple things here. First, just to emphasize, although some would have put forward constitutional challenges to protecting a third party against claimants through the bankruptcy of someone else, that is not the route the court took here. It was a statutory analysis, which means that Congress could change the statute and authorize these kinds of protections. Second, just to underscore what Professor Grove said, in terms of statutory interpretation, Justice Gorsuch cited another decision of his, the Epic Systems Corp, that talked about employment and labor law in combination with arbitration back in 2018. And the short version is, we don't put elephants in mouse holes, is one way sometimes it's put, but that if you're having a list and it has a catch-all at the end, you need to interpret that in context. And here, the other items were about a debtor and their creditors and not a third party in that list. Justice Gorsuch and the majority also went on to do a more contextual interpretation just to bolster the decision he had already reached in terms of examining this statutory section 1123B6. I do want to make clear that this resolves a longstanding circuit split. One wouldn't necessarily pick that up quite from the tone of the dissent about changing practices so much, but in many parts of the country, this is already the law of the circuits. So some matters have been resolved here for the whole country, but as I'm sure we'll get to, there are some open issues that lower courts are absolutely going to have to deal with coming out of this decision.
Mm-hmm. So Tara, Melissa just mentioned the dissent. It was 54 pages long. Justice Kavanaugh wrote it, and it was joined by the Chief Justice, as well as Justice Sotomayor and Justice Kagan. What did it say?
This really comes down to different approaches when it comes to statutory interpretation. And the justices are not always consistent in terms of their own personal approach, but we see these kinds of trends in many other cases involving statutory interpretation. And I do want to underscore that for people who study statutory interpretation, this may seem somewhat familiar. For people who study bankruptcy, what the majority did here was super weird. So what the majority did was say, okay, we're going to look at the text of the statute. We're not going to think too much about the consequences. There are lots of different policy concerns going around. And what we see here is a statute that empowers the bankruptcy court to deal with debtors and people who have claims against the debtors and, indirect liability of debtors. And that's it. So the open-ended language about other appropriate relief must be similar to that. That makes total sense when you look at it from a statutory interpretation perspective. Now, when you look at it from a bankruptcy perspective, a lot of bankruptcy cases, particularly in the lower courts, are driven more by policy, what makes sense. And you can see the bankruptcy court in this case doing that very thing, saying, okay, there are a lot of people who've been harmed. There are lots of states and localities and the US government that have spent a ton of money on the harms of opioids. Let's figure out how to get this settled. Nobody's going to get the deal that they really should, but at least let's get something to the people who are harmed. And how can we figure out a way to get everybody to agree? So that worked out. And that's where the dissent came from. The dissent said, look, this kind of makes sense as a policy matter, and we can read the statute in a broad enough way to allow for that. It's a difference between two types of textualism that I've talked about, a more formalistic kind that the majority used here, but it sure looks like the dissenting opinion is motivated by the fact that, gosh, this was a really sensible solution that the bankruptcy court reached in a really horrible situation, and far less so by what the text of the statute actually said.
So what are the takeaways for the lower courts, Tara?
So one thing we know is that this kind of relief is no longer okay. I think it's also this case, along with some other cases from last term, underscore that the U.S. Supreme Court, really in contrast to the lower courts, is applying a very textualist approach to the bankruptcy clause. Now, I think throughout much of our recent history, the Supreme Court just didn't take a lot of bankruptcy cases. And whenever I talk to bankruptcy attorneys about the Supreme Court, providing resolution of issues, they always said, both bankruptcy and tax attorneys always said, no, we don't want them touching our area. They don't understand it. But the Supreme Court started to do that, right? He's starting to take bankruptcy cases and it's applying a very textualist approach that, much like the majority in this opinion, for the most part, kind of discounts the policy concerns that tend to drive a lot of lower court bankruptcy cases. And I think a challenging question for bankruptcy courts and lower courts reviewing bankruptcy cases will be do they kind of take the hint from the US Supreme Court that textualism is the way to go? And what does that mean for the more policy consequences driven approach that they have taken for so long?
So how about you, Melissa?
Well, we just got a lot of really interesting food for thought
Yeah.
there. And I would first say this is an important reminder, this case, that bankruptcy is a coercive federal power that overrides so much other law. It does make some sense to say we're going to narrowly interpret what's there. And in bankruptcy cases, sometimes that happens and sometimes it doesn't, as Professor Grove has suggested, and it may depend on the kind of case. But this is a reminder that, especially when you're talking about giving relief to a third party that the majority considered equivalent to the crown jewel of what bankruptcy offers, cancellation of liabilities, the discharge, and the majority did make that analogy, then one would expect to see more clear language in that regard. Now, so where do we go from here? The language that was being interpreted here wouldn't only be used for protecting third parties accused of their own wrongdoing, as we saw in the Sackler and Purdue Pharma case. The sky's really the limit of what one could fit in there if the dissent's position had prevailed. So on the one hand, I think courts will see less of that given the direction that they've received here. But let's talk about what the courts are going to see more of, including all up the appellate chain. There's a group of issues that the majority said it was not deciding, including it said it was not touching consensual third-party releases. That goes to party autonomy and contracts, and that's permitted, which raises a question in a case with tens of thousands or hundreds of thousands of claimants. What is consent? How do you know if you have it? Is voting in favor of a plan enough, or do you need a separate documentation? Is not voting on a plan at all, is that not consent, or it is consent? We already had some differing laws on those issues among bankruptcy courts. That's actively being discussed right now. Courts today, yesterday, the day before, are working on this even more fervently. Guaranteed those are going to go up to the district court and appellate courts on this consent question, including what kind of information needs to be included. Do you need to know the firmer scope of liabilities being released? Because that is not always clear in these cases. Do you need to know exactly who is being released? Also not clear in some of these cases. How about who must do the releasing? Is it only people who participated in the bankruptcy? If not, who else? Also needs more work. So those are not easy issues, but the fact is that there is a path forward for involving third parties and getting compromise. The leverage has shifted and the details have shifted in how to do that. I'll end with talking about a special category of asbestos bankruptcies, which in 1994, Congress put a special provision in called 524G to basically say that a prior bankruptcy, the Johns Manville case, was okay. And that has a channeling injunction in it, which is less of an absolute debt cancellation, but performs some of the same functions. I predict we're going to see more attention to the contours of that because some people have read that pretty broadly and say, well, it provides a non-consensual release period. I think courts are going to be asked to look more closely at that language, including on appeal, to say, well, wait a second. Would the Sacklers have gotten a release had this been an asbestos case? I think if you read that language closely, there are some real questions about that and some doubts. So even though that's in the statute, I would expect more litigation of those questions in some cases that are pending now.
I've listened to several discussions about both of these cases over the past year, and this has been illuminating, even despite that. So thank you both for being here and to help other judges understand the opinions.
Thank you so much.
Glad to be here. Thank you.